Well, in terms of type of patents that China offers, it's slightly different from what Canada can offer. And to my knowledge, Canada offers 2 types of patents. China offers 3 types of patents that protect invention, utility model, and industrial design. So for an invention patent, it takes the longest time to apply, and also it takes the most procedure to actually have that all examined and being approved. But it does offer you the most comprehensive coverage. So time-wise, we're looking at about 2 years minimum for an invention patent to be granted. And also procedure-wise, it has to go through all the 5 stages posted by the patent office in China. And also in terms of subject matter covered by the invention patent, it's a lot wider. So it ranges from apparatus, from a method, from the usage, and also microorganisms or chemical materials or even sequencing. So for that, invention really gives you a very broad and stable legal foundation and also to your rights. But at the same time, it does actually cost more time. So the other 2 types that I mentioned are the utility model and the industrial design. Both of them are similar in terms of the procedure-wise are very similar. You only have 3 stages of all the examination. And also it takes about 6 months to 8 months for that to be granted. And the cost is also a lot less in terms of office fees and other translation fees. But the coverage a lot less and they're more specific. And especially with utility model patent, it's very unique in China. It only covers a shape or a structure of a product. So no methods can be claimed in a utility model patent. And for design, it only covers the colors or patterns or the combination of all these, but colors alone cannot be patented. So it really depends on which of the patent is more suitable for your business and how long you wish the production period are for. Because our invention patent is good for 20 years, but the 2 other types are only good for 10 years. And what I also like to introduce here is something that's very unique in China. We call it a dual filing patent strategy, because in China, it allows 2 concurrent patent application of an invention and a utility model at the same time. So if you have a technical solution that you wish to enjoy the patent rights in a smaller or shorter amount of waiting period, you can apply for utility model first. So about a year, you will have your utility model patents granted. You can enjoy the rights, you can start commercializing it, while at the same time, you'll be waiting for invention patent. So after maybe 2 or 3 years, your invention patent will be granted. You can consider withdraw the previous utility model patent, because the later one, the invention patent, already covered most of the areas of your rights. And it also gives you more space to commercialize it. And it also, very importantly, avoid double patenting. So with all these 3, you can combine the utility model with the invention patent, and design is very specific. It only covers certain color combinations and patterns. If you wanted to apply a patent in China as a Canadian company, the best way we would recommend is to file a patent under the Patent Cooperation Treaty, the PCT application we call it. So first you will need to file a local application in Canada, and after the first 12 months of your first application, you'll be able to file a PCT application, which gives you the international coverage of your patent. So all the contracting state to the Paris Convention, which Canada and China, they're both signatory countries, you will be able to use that PCT application during the first 30 months since your first application and choose China as your destination to enter the national phase of the PCT application. And then later on, you can have another 2 months grace period, we call it, is to prepare your national filing in China. So in that sense, it gives you the broader coverage, it gives you a better protection under the PCT because you will have your patents protected in Canada as well as in China. But if you wanted to file your first patent application in China, if you're a Canadian entity, you must have a physical address under your name. So if you don't, you would need an agent acting on your behalf. And also, if you wanted to apply for the first patent in China, we would strongly recommend to look for help because the system in China is quite tricky. There are 3 different types of patent, and each of them has different procedure. Help could really advise you the best filing strategy and your right enforcement strategy. Well, for a patent application, the procedures, there are 5 stages in total. But because we have 3 different types of patents, so for the invention patent, which covers pretty much all the subject matter of all the technical solutions, it goes through all the 5 stages of the application until your patent right will be granted. First, you will need to submit your application. And second, it goes to the first examiner, which look at the formality of your application, and you may receive a few notices asking either to rectify or amend or supply more documentation to your application. And then it goes to the publication period. After the publication period, it goes to the most difficult part, which we call it substantive examination. And this will go to a different examiner compared to the first examiner. This examiner will have very profound knowledge of the area of the technology that you are applying for. So they will look into the details of all the area that you have submitted, the details of your patent and your translations work, and if everything would come together. And during this period of time, you will be expecting 2 to 3 notices, and you will have to answer the questions from the examiner thoroughly by the timeline they're given. So if you might have missed the timeline, you can actually ruin your whole application. So if you successfully passes a very important substantive examination period, your patent should be granted soon. So that's the 5 stages for an invention patent. Other 2 types of patent, which are the utility model patent and the design patent, it takes only 3 stages. You have to submit your application, then it goes to formality check, then your patent will be granted in about 6 to 8 months. In terms of documentations, it does vary from case to case, and from the type of patent you apply, it does differ. But the central piece of your patent application will be the specification and the claims of your technical solution. And if you're using agent, you may need a power of attorney. If you want to claim priority, we may require to submit other files to claim your priority rights. So because China offers 3 types of patents, so each of them do cost differently. But generally speaking, the invention patent will be the most expensive. So if you're looking at invention patent, you will be looking at the complexity of the technology and the claims that you wish to file, and also the number of oppositions that you will be receiving during your application process. So if we look at the rough estimate for mechanical patent, I think about $9,000. And if we're looking at a biological or a chemical patent, that can go about $11,000 to $12,000. So for utility model patent, because it's less procedural and it's less complicated, we're looking at $2,000 to $3,000. And for design patent, that would be the cheapest because it doesn't actually require a lot of translations work. So you can get it done in $200 to $300. So if you're looking at the official fees charged by the Patent Office of China, unfortunately, now they do not actually charge according to the scale of the business. So all the entities will be paying the same official fees. But on that sense, you may also thinking about another fee, which is a professional fee that you may require while you are hiring an attorney or an agent. And for that part, I think lots of the agent will be able to consider the affordability of the applicant to violate that fee.